Hello, GM, and welcome to Web3 Showbiz on Rack Radio. My name is Arturo Choclan, and I'm a practicing lawyer from Spain. In this show, we'll be navigating the entertainment industries, culture, and Web3 from a legal and business perspective. In this episode, we're going to be covering foundational and highly relevant legal issues for the music industry. It's crucial to understand the basic framework of rights on which the music industry is built upon, and several important concepts and legal aspects of the music business that artists should consider to make better informed decisions affecting their careers. This knowledge and the ability to strategically take important decisions can have a great impact on an artist's success in the long run. We're going to be speaking about music copyrights, the legal protection granted to musical works, and its requirements. We could also be studying the two separate copyrights in a song, and the distinction between songwriters and recording artists. Finally, we will review the specific rights that are granted to the author of a musical work. Disclaimer: anything I say should be considered legal advice, and the information I'll be reviewing may differ depending on territory, the time when you listen to it, or attending to the specific case or a particular relationship between the parties. The music industry can be a complicated business. There are many different rights, different deals and contracts, and many parties involved. The first thing we need to understand when navigating the music industry is the basic concepts of copyright law and its relevance for music. What is copyright? Copyright is a legally protected right that secures for limited time the exclusive right of authors to their works. It is a limited duration monopoly, aimed to promote the progress of useful arts by giving creators the exclusive rights to their work for a certain period of time. This time will be, in most jurisdictions, the life of the author plus a stated number of years after his death. After that, every work will pass on to the public domain, so anybody can use it. What is protected by copyright? Ideas are not protected. It is important to understand that copyright protection does not extend to any idea, procedure, process, system, method of operation, concept, principle, or discovery. You can have a great idea for a song, a great theme, an innovative rhythm, or a unique style. If you play your song to someone, or share your ideas with a fellow musician, and this person records it and makes a hit song, you will not have any remedy in a legal proceeding under copyright law, because ideas by themselves are not protected. We will see that an idea alone does not suffice to meet the requirements that we will be reviewing shortly. Before discussing the requirements to obtain copyright protection for a musical work, we should discuss some relevant jurisdictional issues. The requirements for copyright protection are very similar in the whole world. Copyright protection is legislated in each country. However, there is an international framework, thanks to the Berne Convention, ratified by nearly 180 countries, including the European countries and the US. The Berne Convention for the protection of literary and artistic works has three important basic principles. The principle of national treatment implies that works originating in one of the contracting states must be given the same protection in each of the other contracting states. The principle of automatic protection implies that authors will be granted copyright protection for the mere fact of creating their works, so protection is not conditional upon compliance with any formality. Last, the principle of independence of protection establishes that protection is independent of the existence of protection in the country of origin of the work. Apart from this, copyright laws in the US are very important to the global music industry, because it is where the core of the music industry is currently established. To obtain protection, there is no need to register a creative work. In most jurisdictions, copyrights are granted to authors for the mere fact of creating. Protection is obtained automatically. Having said that, there are two basic requirements for copyright protection: originality and fixation. First, originality. The work must have sufficient creativity to obtain protection. A typical chord's progression in A minor will not have protection. That's harmony, and it's too generic. In contrast, a rich arrangement of notes within that A minor harmony could be protected by copyright. We should have in mind that copyright has a purpose: to advance the progress of the arts by granting authors these exclusive rights for a limited time. If copyright were granted to any work, there would be no incentive to be creative, and the arts could not advance over time. However, this threshold of creativity is very low. The quality of the music or the effort to create the work is not what is examined, just that the musical work has a minimum of creativity to be original and legally protected. Additionally, within the originality requirement, the musical work must be a work of authorship. This means that the work must be created by a person, as only a person is considered an author. Works created by nature are not protected. A recording of singing birds will not obtain protection. Works created by machines are also not protected, unless the machine is merely assisting the author in the creative process. For example, a digital audio workstation is just a tool assisting the artist on the creation of the musical work, and, if it has sufficient creativity, this work will be protected. A big topic in Web3 right now is generative art. We have seen NFT collections of generative music created with the aid of artificial intelligence. We will see litigation and extensive doctrine on this issue in the future. Attending to copyright requirements, the key here will be the degrees of involvement of the author and the artificial intelligence in the creative process of the musical work. However, it's important to say that even if works created by nature or machines are not protected, creativity may be found in the selection and arrangement of certain sounds obtained from nature or machines. A good example is the song Train by Paul Kalkbrenner, who recorded different sounds from the trains in Berlin and arranged them with outstanding creativity using those sounds for the song. This arrangement is clearly original and has the required creativity, even if made of sounds generated by a machine. The other copyright requirement is fixation. To obtain copyright protection, the original work must be fixated in a tangible medium or means of expression. Typically, this medium must be lasting, meaning that the work can be communicated for more than a transitory duration. For example, in music, the musical work must be written or recorded. And this is how an original idea automatically becomes a copyrighted creative work. In music, every individual song has two separate copyrights: the composition and the song recording. In a musical composition, the lyrics and the melody of the song are protected. In a sound recording, the recorded performance of the composition is what is protected. This implies that authors of musical works would obtain publishing rights and rights over the recorded music in a separate way, which are divisible and exploited independently. This is also significant when doing business with music publishers and record labels. As a musical artist, you can be a songwriter, a recording artist, or both, and you can make money by exploiting your exclusive publishing and song recording rights as an independent artist or as a signed artist. What specific rights does copyright grant to an author? Copyright grants the author of a creative work the right to do certain things in exclusivity, so no one else can do those things unless they are granted permission. There are two branches of exclusive rights: the exploitation rights, or the rights to commercially exploit your work, and the moral rights, which are more common in civil law jurisdictions. This includes the right of attribution, or the right of the author to be recognized and credited as the author of the work, and the right of integrity, the right of the author to object to any alteration, distortion, or mutilation of the work that is prejudicial to the author's honor or reputation. We would be focusing on the copyright exploitation rights with regard to music, that will imply different revenue streams for artists. These are the right to reproduce the work, to distribute copies, to perform the work publicly, to make derivative works, and the right to display the work publicly. The exclusive right to reproduce the work in music means making copies or phonorecords of the musical work. For example, if you have written a song as a songwriter, unless you grant permission, only you can record it, allow it to be played on TV or on a podcast, or make any other type of copy or reproduction of the song. The right to distribute copies of the work includes shipping CDs or vinyl to the public or to record stores, uploading it to websites so the public can download it, and streaming it through Spotify or Apple Music. The right to perform the work publicly includes playing the song anywhere where it may be heard publicly. For example, in venues, concert halls, on TV, in shopping malls and stores, airports, on the radio, in nightclubs and bars, or by streaming. What is considered a public performance may vary depending on the country. The next exclusive right is the right to make derivative works. Derivative works are works that are based on or derived from a pre-existing work. The original work does not need to be copyrighted, because you can make a derivative work, for example, of a song in the public domain. In music, you can think of a remix or an original arrangement of a song. Finally, the right to display the work publicly involves, for example, displaying lyrics or notation of your song on a website. Think of Genius Lyrics and sites like Ultimate Guitar Tabs that shows the charts for how to play a certain song with the guitar. The music industry is built upon these foundational legal concepts we just reviewed, that are present in every business deal. In this show, we will be navigating the different areas of the music industry and the major issues that artists should understand to have a successful career in this business. With these foundations, upcoming episodes will cover the different revenue streams for artists, music publishing, record label contracts, and the intersection between the music industry and the promising developments in Web3, among other topics. Thank you very much for listening, and see you in the next episode of Web3 Showbiz on Rack Radio.